Good morning, everyone. It is 7 a.m. I'm starting the Wayne Township Board of Trustees meeting. I'm echoing a bit, Bruce, but that's okay. Probably because I have you too close. Can you hear me okay, Bruce?
I can.
Okay. All right, so let's do a roll call. Mr. Jacobs?
I'm here.
All right. Ms. Colvin, I'm here. And Mr. Hoffman is not here. We have Bruce McGarry on the phone. He's our prosecutor. So let's do the Pledge of Allegiance, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, the purpose of our meeting today is to review and sign an adjustment to, an amendment to a resolution that we had previously about the sale of the old fire station. And Bruce, my only question is about the payment of the survey that was in here. Is that still valid?
Yeah, let me update you on that. When we originally were contemplating that there could be a need for a survey, and I incorporated that into the resolution and the addendum number 1 to the purchase sales agreement that I emailed to all of you. I was under the impression that we would not, meaning the township would not be able to transfer the old fire station to the buyer because there were problems with the legal descriptions.
Okay.
And at that time, I didn't give it a lot of consideration, but after that, I did give it further consideration to the point that it would be my recommendation, contrary to what I put in those documents, that is not the township's responsibility. And here's why. As I explained in some email communications, for a deed to be recorded, it first has to be reviewed. The legal description of the deed has to be reviewed and approved by the Warren County Engineers Tax Map Department. It's just standard protocol. You go there first, you get it reviewed and approved. You go to the auditor's office to get it transferred, and finally you go to the recorder to get it recorded. And if there is a problem with a legal description to where the description is bad, or even to the point that the county engineer tax map department could determine that a new survey is required, then that deed would not be allowed to be recorded until such things occur. But I had not thought about until yesterday that under the county engineer's rules, there's a set of published rules that are online at the county engineer's website called the conveyance standards. And under the conveyance standards, there is an exception to the rule. Actually, there's more than one exception, but the exception does apply here because you are a political subdivision. So if there's a bad legal description or a new survey that would ordinarily be required, the political subdivision is allowed to transfer the property and doesn't have to get a new survey. It doesn't have to go to expense.
Okay.
What happens in that circumstance is if that occurs, then the next time a deed gets recorded, unless it is another political subdivision, would be one of the exceptions, meets one of the exceptions, then a new survey is required. So if this transaction closed, and I've already prepared the deed, I shared that with you property to the deeds. The rub is that in the future, if the deeds ever sold the property or conveyed it in any way to anyone else, for estate planning purposes or whatever the case may be to themselves, the tax map department has determined that they would have to obtain a new survey. The additional rub in this circumstance is they are borrowing money. The borrower, they've applied for a loan from is LC&B, and LC&B is mandating that they buy what's called a lender's policy of title insurance. There's also what's called an owner's policy of title insurance, where the insured, it would be the deeds, and the deeds will have the right to purchase that as well. But LC&B is mandating as a conditional loan that they buy this lender's policy of title insurance. And I talked to the attorney who is the owner-operator of the title insurance company, and he indicated he would talk to LC&B. He has not gotten back to me with a final say, but he pretty much could guarantee that LC&B will not allow this loan to go forward, and that's between the deeds and the bank, not Wayne Township. In other words, they will not approve the loan and fund the loan and close the transaction unless that issue is resolved. Because the way they look at it is, if the deeds defaulted on their loan and they had to file a foreclosure action, because this new survey required is part of the county's requirements, they then would have to hire and pay for a new survey, they being LC&B, in order to even foreclose on the property. So they won't allow that. And the only thing it would result in is they would end up telling the deeds, we're not going to loan you the money unless that gets resolved. The second problem, as I pointed out in an email to you as well, is if you look at the attachment to the email from Bob Fox, our director of the tax map department, he indicates that there's a dispute over who owns a certain part of one or more of the lots. And if you look at those legal descriptions that I put in these documents, like the resolution, I think I put it in the resolution, and I also put it in the amendment number of the purchase sales agreement. I pasted the identification. It's not the technical legal description, but there's enough there. If you look at the technical description that's in the current deeds of record, where Wayne Township acquired title to these properties, some of those partial lots apparently are shown in the neighbor's deed as the neighbor owning it. So it's like a boundary line dispute or an ownership type dispute, and that's another issue that the title company, now that they've seen Bob Fox's attachment to his email, they'll take issue with that as well, and they won't approve the loan or close the loan with that being outstanding. So, in a nutshell, to try to summarize what I just said more succinctly, it's not Wayne Township's obligation to get a survey, because Wayne Township can convey title to the buyer and a deed could be recorded. The deeds, however, will not be able to get their loan from LC&B. That doesn't mean they can't go get a loan from someone else, but I anticipate that being coming to fruition once I hear back from the attorney. But for purposes of today, the resolution that you have and the amendment number 1 is all okay, and you could adopt it. It would be, it's up to you. You can decide whether you want to participate by paying for a survey. But even if you got a new survey, you still have this boundary line I would ask them to sign a quitclaim deed to us. Quitclaim deed just means there's no warranty being given,
Right.
unlike a general warranty deed or a limited warranty deed. It just, quitclaim deed just simply says, whatever interest, ownership interest, rights, title that I might have, and I'm not making any representation or warranty what that is, I'm giving to you. I'm just conveying it to you. So that would have to be worked out with the property owner. And we might be able to get that resolved simply by a quitclaim deed. Or the map department could say, well, you can't even do that without a new survey. I don't know until we'll cross that bridge when we get to it. If the property owner, the adjacent property owner, did not amicably agree to resolve this, then we would have to go to court and file a declaratory judgment action seeking quiet title, it's called, for a court order that part of a lot or a part of more than one lot that's in dispute. We would ask the court to order that that's actually owned by Wayne Township. And if we had to do that, that could take a long time. And a long time I would define as a minimum of probably 8 or 9 months, and it could be a year and a half to do something like that. The other thing I would point out, just as a reminder to you, is on the survey, because the way the docs are originally written today, if there is a requirement for new survey, and again, there's not for Wayne Township to transfer it, but before, I thought of that, we were just going to go ahead and obligate the township to pay for that. Now, again, I don't think that's Wayne Township's obligation to do that, and shouldn't have to do that. So, at this point, if we adopted these two documents, the resolution and approving the amendment, and you signed it today, I think we need to strike those paragraphs relating to paying for the survey, and at a subsequent regular or special meeting, if it came down to something that the township needed to do related to that, we could do another addendum to take care of that. So that would move the ball down the field today to get those two things done. And if we have to come back together at a future date and buy another addendum to add some stuff related to a survey or however this is going to get worked out, we can do that. So that would be my recommendation. Just there's a whereas clause in the resolution that talks about the survey and fiscal officer being authorized to pay those expenses or invoices. There's also a paragraph, and I'll try to pull it up.
Yeah, I think section 4 is what I see on the resolution.
Okay, so section 4, and then I also had it in the documents.
Yes.
So, I can always tweak both of those on my end. You're only obligated to read a resolution into the record by title only. I think I did put something in the title related to the survey, and you can just delete that as well, and then that would move us forward today. But I'm convinced that this is not going to work as is, that the bank will not approve the closing of this loan, and this is not going to come to fruition. And maybe the deeds agreed to pick up and take care of a new survey, but again, it really doesn't resolve the boundary line dispute, which is something we, the township, would have to resolve. And let me say, for those, I think you guys are on YouTube, if anybody's following this, as the trustees know, these are all deeds that go back a number of years. One of the deeds, an issue has a defect. That deed goes back, as of December, it'd be 15 years. And back in those days, the requirements for legal descriptions weren't as detailed as they are today because they didn't have the technology we have today that surveyors have with GPS devices and all that sort of stuff. So we have these rules today that they didn't have back then. They could get away with descriptions that weren't the greatest descriptions in the world, and that just doesn't work anymore. So I know I said a lot, but the trustees are aware of pretty much everything I said because of emails that I sent you guys yesterday, and I'll answer any questions you might have.
All right, so I will start with, we did find a person that's willing to sign an affidavit that Orville Phillips was not married at that time. We found his obituary as well, listing no wife or former spouse or any children. So that's good news on that. And we, my other question is about if we wanted to pay for the survey, would we be allowed to do that based on this county engineer's office conveyance standards?
That's a judgment call on the board of trustees' parts. Again, my recommendation is you don't agree to that because you don't have to do it because of the conveyance standards making an exception for the township. If you decided it was in the best interest of the public and wise to spend that money, the taxpayers' dollars on such an expense, I think you have the authority to do that. This, for the record, this went through a competitive bid scenario, and you had more than one bid, and you know what the gap is between the lowest bid by the Deep Plumbing Company LLC and then the next lowest bid, which I remember was the village.
Right.
So there's a big gap there, a gap that you may or may not want to reconsider, because if the village bought it, the village wouldn't have all these issues because they probably would not be borrowing money, and if the village bought it, they would never, most likely not ever sell it. It would just be owned in perpetuity. Or if they did sell it, then they meet the exception as well, and they would be able to convey title to it because the deed would be allowed to be recorded. So that is an easy way out of this, just to reject, say the deed you didn't close within the 30 days, and we reserve the right through the competitive bidding process to reject your bid. We can go to the next lowest bid. But monetarily, though, there's a big gap in that difference between the two bids. And, you could say, well, we're going to spend, I don't know what it's going to cost, $5,000 or more to get all the surveying work and all that stuff done. And that is a lot less than the gap between the lowest bid and the next to the lowest bid. But you're also going to have to deal with this other issue. Luckily for you, you're not going to incur legal, meaning attorney's fees, because the prosecutor's office by statute represents you. There would be court costs if we had to go to court and file a declaratory judgment action. So you would incur some costs there, but they wouldn't be that significant. Court reporter fees, expert witness like a title company or an attorney, a title attorney, you'd have some expenses there. So, again, it's just a judgment call on your part. The rub, though, is the fact that getting a survey, even if you agree to do a survey and get it all worked out, and it may be more than a survey. It may not just be a simple survey. It could be going through the replanning process with the village, planning commission, which adds to that expense. But even if you did all that, it still doesn't necessarily resolve these two deeds in conflict unless you could get it resolved, amicably. It doesn't resolve that. So there's really two problems that have to be resolved. So getting a survey doesn't necessarily resolve both issues. It only would resolve one. And again, that would be a judgment call on your part. And I think for purposes of today, you don't have to make that decision. We can wait to hear back from the title company attorney for LC&B and come up with a plan strategy and do another amendment. We have to do another amendment anyway if something is going to be done, because we're going to have to extend it more than 60 days.
Right. So is the little lot in question, is it this little 5-foot thing between, to the, which side is that? That is the southeast side of, next to Glenna Carey on that original little map?
Yeah, I don't have it in front of me.
Okay.
And I don't think Bob Fox really elaborated.
Okay.
Or if he did, I'd have to research that deed and figure that out. And I could do that easy enough, but I just don't have that information at the moment.
Yeah, I'm just trying to figure out which property owner we would have to deal with here. Current property owner.
Right. Understood.
Would it be beneficial, you think, for me to go talk to Bob Fox down there and try to get a better understanding?
No, I'll
Okay.
figure that out. I can
Okay.
figure that out easy enough and email you what it is.
Okay.
So, again, to condense this down succinctly, I recommend that you adopt the resolution, but strike through the top part of the title that references the survey and the fiscal officer paying invoices on both the whereas clause and the paragraph of the resolution. And then on the agreement, we'll strike both those same things. And if you adopt the resolution today, and you sign the addendum, put the strike-throughs through that language and initial next to it.
Okay. Questions? Do you have questions, Andy?
Yeah, I think you answered them all. The emails were very good. Yeah, I think we continue to move the process right now and see what we get to the next level of it.
Okay.
Yeah, like I said, it's approve these two, approve the addendum, approve the resolution. And then see the next part, like you gotta find out the parcel, you gotta find out what it says.
And
those steps.
I guess we should move forward with the person signing the affidavit also on that unmarried man.
Yeah, you should do that,
Okay.
get that person, and I can write the affidavit. I
Okay.
just need to know who the affiant is.
Okay, we'll get that to you.
How they know them, how long they've known them, how they know the person was unmarried. The other thing too, I just thought of while you brought that up a moment ago, is we could always get that person's death certificate from the Board of Health. I assume that person died in Warren County.
Yes.
And a death certificate would list a person's marital status.
Okay. Yeah, I asked Stubbs Connor Funeral Home, they're the ones that did it, but they'd have to go up into the attic, to get the records from 83, so, but yeah, you're right, we can go to the county as well.
Yeah, so either they have it or we could go to the county health department to get that.
Okay, well, we'll send you the information on the affidavit person. Scott Camry knows them, he's sitting right here, so he heard you, so he'll get all that information and I'll send it over to you.
Okay, and I will, when I get in the office today, some point today, I will get you that answer about where the encroachment is, which adjoining property owner, and how many of the partial lots that it impacts.
Okay, I appreciate it.
Okay,
All right.
anything else for you?
Clear as mud, I think we're good, Bruce.
All right, for now, it's my job to keep in the mud for you.
Okay,
We'll do that.
we appreciate you. All right,
All right,
thank you.
all right, goodbye.
All right, any discussion internally?
So you gotta strike through that one thing, so.
Yeah.
Okay.
So it's up here at the top, and let's see.
Morning.
So this would be resolution 2026-34, we're up to. Today is March 12th, so topic of resolution, approving and authorizing the board president to sign addendum number 1 to the purchase sale agreement for the old fire station, authorizing the board president to execute a deed of conveyance to the buyer along with all closing documents in the name of and on the board's behalf. And then this is the last part I think we want to strike, and authorizing the board president to procure professional services and the fiscal officer to pay invoices related to if needed.
Yeah, strike it.
Okay. All right. And then the section down here is section 4. In the event that Warren County Engineers Tax Map Department determines the legal description, the existing legal description for any and all of the parcels identified above contain a bad legal description or require a new survey or replat to create a new legal description in order for the deed of conveyance to be recorded, the board's president is authorized to execute another addendum to the PSA to extend the closing date for such purpose, to execute an engagement letter agreement with a licensed surveyor or civil engineer firm to complete the professional services, and should such be required, the board hereby authorizes the fiscal officer to pay the invoices for such professional services.
We're striking that as well.
Yes. That goes with the top part up here. Yeah, you missed the big part, Scott. I don't think there's anything else in here about the survey. So this is E.J. Deaton Properties LLC.
So basically, we're making the change. With the buyer. Because it was EJ
Right here.
LLC.
Okay, let's read this here. Whereas the existing legal descriptions for the above identified parcels date back to 1950, 53, 85, and 90 respectfully, may be determined by the Warren County Engineers Tax Map Department to be bad descriptions or require a new survey and/or replat in order to create a new legal description necessary to record the deed of conveyance. In such event, the board deems this responsibility of the board under the PSA. And that is not true, right? So we just leave the part that it may be necessary. So we're getting rid of the in such event portion. Okay, so section 1 is approving addendum 1 of the sales agreement, authorizing the board president Diane Colvin to execute addendum 1 to the PSA. Section 3 is authorizing President Diane Colvin to act on behalf in the name of the board by executing the deed of conveyance to E.J. Deaton Properties and a settlement statement, affidavits, receipts, all that stuff. Basically to do the closing. We got rid of 4. 5 is the board is acting in its administrative capacity in adopting this resolution. 6, that the recitals contained within the whereas clause set forth above are incorporated by reference herein. 7, that it is found and determined that all former actions of this board concerning and relating to the adoption of this resolution were adopted in an open meeting of the board in compliance with all legal requirements. Did you read anything? Just to double check that?
No, I got to see the emails and stuff that
Okay.
he passed through. Yeah, he said remove section 4. Remove the conveyance up there, so we did that. So that'll be fine. Yeah. he said to go ahead and approve this to keep it moving forward.
Right.
And if there's any other snags or anything else we run into, we'll take them piece by piece.
I'm sure we'll be back on it Tuesday. Our-
Yeah, we can have
Our
a
regular
discussion,
meeting,
yeah. Well,
Probably
he'll
here.
be able to come back with some things today and
Yeah.
on Tuesday as well, so that's good there. So this continues the process moving forward
Right,
and, doesn't put us on for paying any kind of surveys right now as we speak, so
Right.
that's good. So I'll make a motion to approve, it was resolution 2026-34.
Mr. Jacobs. I will second that.
Okay.
Do you wanna do the roll call since you're here?
Alright. Okay, Ms. Colvin?
Yes.
Mr. Jacobs?
Yes.
Alright,
And,
resolution passed this
12.
12th day of March.
all right,
I'll let you see it as well.
I will, if there's no other discussion, I will make a motion at 7:32 to close to adjourn the meeting.
I'll second.
All in favor of adjourning, say aye.
Aye.
Any nays, like sign, motion's carried.